Good morning. We're going to go ahead and get started. My name is Katie Triska. I am a shareholder in Reinhart's Labor and Employment Department. The reason that I decided to offer this seminar today is every day I'm helping employers manage FMLA issues, whether it's, does this person have a serious health condition? Can I get a second opinion? I think this employee is abusing FMLA. What can I do? And the frustration that I hear from employers is that, they think they're doing things right. They're complying with federal FMLA, only to learn, though, that, they also have to comply with Wisconsin FMLA. And with respect to certain issues, Wisconsin FMLA is different than federal FMLA. And so the purpose of the presentation this morning, I'm not going to be giving an overview of each law. I'm not doing FMLA basics today. This is going to be focused strictly on the differences between the two laws and what you need to do in light of those differences. Before I get into the speech, I wanted to cover a few hot issues that you need to know about. The first is an increase in on-site audits. The Department of Labor recently announced that it will be increasing its on-site visit to employers. During these on-site audits, the investigators may review your FMLA forms, FMLA policies, FMLA files, and also interview employees. In light of this, I encourage employers to be proactive and begin a self-auditing process, making sure that your policies and forms, practices, records are all compliant. As you may know, these records need to be maintained for at least 3 years, and these records should be maintained in a separate confidential medical file. If these records are in the employee's personnel files, that will be a problem. Also, make sure that your worksite has the FMLA poster prominently displayed. The regulations require employers to translate this poster into other languages if you have employees who speak languages other than English. The second hot issue right now relates actually to wage and hour litigation. As you may know, there's been an increase in wage and hour litigation, but at the same time, there's, or probably perhaps because of, there's been an increase in employees' ability to work from home or off-site. And so what employers are finding is that they have employees who are on FMLA leave, and either voluntarily or involuntarily, they're performing work while on FMLA leave. This raises a few concerns. First, if they're performing work involuntarily while on FMLA leave, then they may be able to claim that the employer interfered with their FMLA rights. Second, whether they're performing the work voluntarily or involuntarily, if they're not being paid for the work they're performing while on leave, then that could give rise to the wage and hour claim. So depending on the employee, it may be appropriate to cut off their ability to access the company's computer systems while they're on FMLA leave, or to instruct them in writing, have them sign an acknowledgement that they're not to perform any work while on FMLA leave unless specifically approved by HR. So as you know now, there's two different laws, federal FMLA and Wisconsin FMLA. When they're different, what you're going to see today is that the rule that's more generous to the employee is the one that we need to comply with, and that trumps. And so there will be times when the state law will trump the federal law. So to begin, under Wisconsin law, in order to be eligible for FMLA leave, the employee must have been employed for more than 52 consecutive weeks. Significantly, it does not need to be the 52 consecutive week period prior to the request for leave. And so in theory, you could have an employee who worked 6 years for the company, took a few years of break, returned and started working for you for 6 months, and they would have satisfied that requirement because they have worked 52 consecutive weeks. Second, they have to have received pay for at least 1,000 hours during the preceding 52-week period. It's not that they had to have worked for at least 1,000 hours, just paid. So you would be looking at sick days, vacation days, holiday pay, in calculating whether they've received pay for at least 1,000 hours. And then the last requirement is they have to work for an employer that employs at least 50 employees. And these 50 employees can be located anywhere. And out-of-state employers get themselves into trouble with this requirement because they assume since they have less than 50 employees in Wisconsin, they're fine. But that's not what this says. It says if you have 50 employees anywhere, if you have even one employee in Wisconsin, that one employee would satisfy the requirement. So in contrast with federal law, they have to have been employed for at least 12 months. Here, there's no requirement that the 12 months be consecutive. They have to have actually worked for 1,250 hours over the previous 12 months. So unlike Wisconsin FMLA, we're looking at hours worked. Any paid time off, vacation, holiday, sick days would not count towards the 1,250 hours. And they have to be employed at a facility where at least 50 employees are employed within a 75-mile radius. And so you'll see with Wisconsin and federal here, it's much easier for an employee to become eligible for leave under Wisconsin's law. Leave availability is also different between Wisconsin and federal law. With Wisconsin, an employee is entitled to 2 weeks for their own serious health condition, 2 weeks for the serious health condition of a family member, and they're also entitled to 6 weeks for the birth of a child or placement of a child for adoption. As we'll discuss later on, these are separate entitlements. And so if they use 2 weeks for their own serious health condition, they're still entitled to the 2 weeks to care for the family member and the 6 weeks following the birth of a child. Under federal leave, we're looking at a cumulative total of 12 weeks. They have up to 12 weeks that they can use for any combination of reasons. Their own serious health condition, their family member's serious health condition, to care for a child or placement of a child for adoption or foster care. Unlike Wisconsin, federal does cover foster care. It also would cover incapacity due to pregnancy and for prenatal care, and qualifying exigencies due to a family member's call to active duty. The regulations also explain with respect to qualifying exigencies that an employee may be able to take leave to care for the parent of a military member. And so if we have, a military member who's been called to active duty, his parents need assistance because they're incapable of self-care. While generally in-laws aren't covered, in these circumstances they would be. And then in addition to those reasons for which there's that 12-week cumulative, there's also 26 weeks of leave that are available under federal law to care for a spouse, child, parent, or next of kin who is a covered service member with a serious injury or illness. This leave is non-renewable and any unused leave is forfeited. The 12-month period, regardless of what calendar year you usually use, for this type of leave, the 12-month period begins on when the individual started using the leave. This leave is based on a per service member and per injury basis. And so we can't have someone use this leave twice for the same service member for the same injury. But if we have the same service member who, for whatever reason, has a second injury, then they could use this for the same service member twice. or they could use this leave twice if they have two service members in their family that they need to provide care to. But regardless, they can't take more than 26 weeks in a 12-month period. So in light of this, what do we do? If we have someone who's using federal FMLA, we need to make sure that that's not affecting their Wisconsin leave availability for other reasons. And so if we have someone who uses 12 weeks of federal FMLA for the birth of a child, while we could run that simultaneously with Wisconsin's 6 weeks of leave, the employee would remain entitled to 2 weeks of Wisconsin leave for their own serious health condition and 2 weeks of Wisconsin leave for their family member's serious health condition. So we'll go through some examples where you'll see that employees can get more than 12 weeks of leave per year. So first example, we have an employee, and we're assuming a calendar of leave year basis to keep things as simple as we can this morning. I know it's early. The employee takes 12 weeks of leave beginning February 1st following the birth of a child. So this is accounted then against the 12 weeks of federal FMLA and their 6 weeks of Wisconsin FMLA. In July, this employee wants to take 2 weeks of leave to care for his mother due to her serious health condition. Do you let her? Yes. You would treat that just as Wisconsin FMLA because they've exhausted their 12 weeks of federal FMLA. In October, the employee requests 2 more weeks of leave due to his own serious health condition. Is he entitled to it? Yes. Again, not entitled to any more federal FMLA, but he still has the 2 weeks of Wisconsin FMLA available to use. Okay, another example. In March, we have an employee who requests FMLA leave due to his own serious health condition, but he's only worked 1,100 hours. So he doesn't qualify for federal FMLA. But the employer goes ahead and approves 2 weeks of Wisconsin FMLA. In September, the same employee requests FMLA leave due to his own serious health condition, but now he's worked in excess of 1,250 hours. Is he entitled to more time off for his own serious health condition? Yes, but this time the leave would only be counted as federal FMLA because he's already exhausted his 2 weeks of Wisconsin FMLA for the year. But he's entitled to the full 12 weeks of federal FMLA. So let's assume then that this employee took 12 weeks of leave in September due to his own serious health condition. In December, the employee requests more time off to care for his spouse with a serious health condition. Is he entitled to it? Yes, under Wisconsin, he's entitled to 2 weeks of leave in any leave year to care for a family member with a serious health condition. Does that all make sense? Okay. And we'll have time at the end for questions too. With respect to leave that's available for birth, adoption, or foster of a child, Wisconsin says that this leave has to begin within 16 weeks of the birth or placement, and only 6 weeks can be taken with respect to any birth or placement. As I mentioned earlier, it does not cover foster care. Parents working for the same employer are each entitled to the full 6 weeks. And under Wisconsin FMLA, employees have the right to take this leave on an intermittent basis. And you'll see how things are different under federal law. So under federal law, we have 12 weeks of leave that are available, but the leave must be concluded within 12 months after the birth or placement. Parents who are working for the same employer are entitled to a combined total of 12 weeks of leave to care for a child, assuming there's no serious health condition for the infant if they are married. If they're not married, then they each can receive the full 12 weeks. Under federal law, employees are not entitled to take leave to care for a new child on an intermittent basis and may do so only if the employer consents to it. The other interesting thing is that FMLA will not limit it to 12 weeks total. It's 12 weeks in a leave year. And so if we have an employee who was born, an employee whose baby was born December 1st, they take 4 weeks of FMLA leave. If you're on a calendar year system, come January 1, that employee gets another 12 weeks of leave available, as long as the leave is concluded within 12 months of the birth. And so if that 12-month period falls within 2 leave years, they could, in theory, take 24 weeks following the birth of a child. Does that make sense too? Okay. So, as you've seen, they're very different. So what we need to do is for the first 6 weeks of an individual's leave, assuming they qualify for both federal and state, we need to allow the employees to use their leave on an intermittent basis if they choose to. This comes up more frequently with the dads. The moms usually are out the full initial 6 weeks. But with dads, if they want to use their Wisconsin FMLA intermittently, they can. Now, once they've exhausted their 6 weeks of Wisconsin FMLA, then we only need to be worried about the federal rules. And federal says intermittent leave is granted at the employer's discretion. And so once they've burned up that 6 weeks of Wisconsin FMLA, if you no longer want to allow them to use that bonding leave intermittently, you can prohibit it. There's a lot of lingo on here. I'm going to try to get through it. It's messy. Please let me know if you need me to repeat anything. So, under Wisconsin, a serious health condition is defined as a disabling physical or mental illness, injury, impairment, or condition that involves inpatient care in a hospital, nursing home, or hospice, or outpatient care that requires continuing treatment or supervision by a healthcare provider. Continuing treatment under Wisconsin means direct, continuous, first-hand contact by a healthcare provider subsequent to the initial outpatient contact. In other words, it's outpatient care that requires direct follow-up care by a healthcare provider. Unlike federal law, no period of incapacity is required. And so as long as, to meet this continuing treatment, if they have 2 appointments, even if they don't have any period of incapacity, they may qualify for leave as a serious health condition. Okay, federal. The inpatient care is pretty similar, where we're looking at injury, impairment, physical, mental condition that involves incapacity or treatment and includes an overnight stay in a hospital, hospice, or residential medical care facility. The continuing treatment is different. We're looking at making sure they've had an incapacity for more than 3 consecutive days, and there must also be involved either treatment 2 or more times within 30 days of the first day of incapacity, or treatment on 1 occasion that results in a regimen of continuing treatment. The initial or first visit must occur within 7 days of the first day of incapacity. I'll say that again. The initial or first visit must occur within 7 days of the first day of incapacity. There's other types of continuing treatment that constitute a serious health condition, and I'll just touch on these very briefly. Chronic conditions, that might be something like migraine headache, permanent or long-term condition. Alzheimer's is a common example. Multiple treatments, kidney disease, cancer, and then pregnancy or prenatal care. So what to do? If an employee only satisfies the Wisconsin or federal definition of serious health condition, then we need to only grant that leave. If they only satisfy the federal definition, you can't count it against the Wisconsin FMLA and vice versa. So it is important when you are looking at the certification to go through the test for both Wisconsin and federal, so you know whether to designate it as, one, both, neither. If you're not looking at both tests and saying, well, it meets federal, approve, you're ignoring the Wisconsin FMLA, and you need to designate it as Wisconsin FMLA or not. And for your records, you need to be able to show whether this was treated as Wisconsin FMLA or not. So for example, again, assuming a calendar leave year, if an employee's only worked 1,100 hours as of March and needs leave due to a serious health condition, the employer should deny federal FMLA, but grant the 2 weeks of Wisconsin FMLA. If the employee needs more leave in the summer after they've worked more than 1,250 hours due to a serious health condition, then at that time you would approve the federal FMLA, but deny the Wisconsin FMLA because they've already exhausted it. So in that leave year, the employee would have received 14 weeks of leave due to their own serious health condition. My recommendation, if you're using the Department of Labor's standard forms, would be to work with counsel on revising these forms to include references to Wisconsin FMLA. I like to include check marks, boxes that you can check, where you specifically state, yes, Wisconsin FMLA was approved, no, it wasn't. If you're just using the Department of Labor's forms, they don't have places for you, to reference Wisconsin leave at all. With leave years, Wisconsin says you must use a calendar year basis when calculating an employee's leave availability. Have to. Under federal law, you have options on how you can calculate it. You can calculate it on a calendar year basis, similar to FMLA. You can use any fixed 12-month period, such as your company's fiscal year. You can use a 12-month period measured forward from when they use leave, or a 12-month period measured backward from when they use FMLA leave. So what leave year should you use? Well, under Wisconsin, you have to use the calendar year basis in calculating Wisconsin FMLA, but you can select a different leave year for your federal leave. Administratively, I know that sometimes causes headaches, and it's easier to just use a calendar year for both. The problem with the calendar year system is that it's easier for employees to abuse FMLA. Whenever we're using like a rolling backward period, it makes it a little more difficult for them to abuse it. The other problem that employers have with calendar leave years is if someone uses 12 weeks of year at the end of the calendar year, come January 1, they can be out another 12 weeks, and that's, for an employee to be gone 24 consecutive weeks often results in a hardship for the employer. So things to consider. The definition of family member is different under Wisconsin and federal law. Wisconsin includes parent-in-law, unlike federal law, except for military, thank you. It also includes domestic partners and parents of domestic partners. Adult children may be considered a quote-unquote child if they're incapable of care due to their serious health condition. Federal law, this continues to develop. After the Supreme Court addressed the Defense of Marriage Act, it's really opened the doors for states to decide how spouse should be defined. And so if you have an employee who's legally married to a same-sex partner because they went to a state that recognizes same-sex marriages, and they live in a state that also recognizes same-sex marriage, then that employee will be entitled to take FMLA leave the same as any spouse. The Department of Labor hasn't addressed yet what would happen if someone was legally married but then moved to a state that doesn't recognize same-sex marriage. The expectations are that the Department of Labor will take the position that a spouse will include anyone who is legally married regardless of where they currently live. What's important to keep in mind is we're looking at where they live, not where they work. And so if you have an employee who lives in a state where same-sex marriage is recognized, but they work in a state that doesn't, you would recognize their partner as a spouse because they live in a state where same-sex marriage is recognized. In loco parentis is a concept that's also unique to federal law. What it says is that other than legal parents, biological parents, an individual may be your parent if when you were a child, they took responsibility for your care and financial support. Caregiver leave, it would include a service member's next of kin, which is the nearest blood relative other than a spouse, parent, son, or daughter. Federal also recognizes that at times an adult child may be considered a quote-unquote child, but here they would have to be incapable of self-care due to a disability. Given that the definition of disability is defined very broadly under the ADA, more adults may be eligible to care for their adult children because this is no longer so difficult to establish. Regardless, Wisconsin's definition is even broader because the adult child only has to have a serious health condition that makes them incapable of self-care. When we have employees that go on FMLA leave, particularly intermittent FMLA leave, one of the questions I get a lot from employers is, can I move them to a different position? Under Wisconsin, no, you can't. And so what you need to do is wait until their Wisconsin FMLA leave has been exhausted, and then at that time you just have to comply with the federal rules and make sure the reassignment's permissible. Or you can always ask the individual if they'll voluntarily agree to the reassignment. If they agree to, I'd recommend following up with an acknowledgement in writing where it's clear that this is voluntary on their part and that they're not under any duress in agreeing to the reassignment. So under federal law, in order to reassign an employee, the leave must be for on an intermittent or reduced schedule leave. That's the only time it's permissible. In addition, that reduced leave or the intermittent leave has to be due to planned medical treatment or a period of recovery due to a serious health condition or the serious health condition of a family member or an illness or injury of a service member. This is frustrating for employers because when you want to reassign employees, it's often because their absences are intermittent and unforeseeable. In those cases, you can't reassign. It has to be foreseeable. It would also be permissible to reassign if the employers agreed to permit someone to use leave on an intermittent or reduced schedule leave due to the birth of the child or placement of a child for adoption or foster care. The reassignment has to be limited to the period that the individual needs leave, and it has to be for a position that has similar pay and benefits. We can't transfer employees to positions to discourage them from taking FMLA leave, So for example, I would discourage employers from transferring a white-collar worker to a janitorial position, even if the pay and benefits are the same, because I think an employee could argue that that reassignment was punitive. As I mentioned earlier, if the intermittent leave is needed on an unforeseeable basis, we can't reassign them. So what to do? Again, wait until Wisconsin FMLA has been exhausted before requiring reassignment. And then you would have to make sure that the reassignment was permissible under federal law. The other option you have under both Wisconsin and federal law, even if the reassignment isn't permissible, the employee could always voluntarily consent, but again, you'd want to make sure it's approached in a way where it's clearly voluntary on the employee's part. Under Wisconsin FMLA, an employer cannot require an employee to substitute paid leave, but the employees may choose to. And what's interesting about Wisconsin FMLA is that even if the paid leave policy doesn't cover the type of absence, employees can substitute any type of accrued paid leave for their absence. And so the example I give here is if someone could use their sick days to bond with a new child, even though the child's healthy. So we need to make sure that we're not limiting their ability to substitute paid accrued leave, even if it doesn't really fit with the circumstances of their FMLA leave. Under federal, we can require employees to substitute paid leave. An employee may also opt to substitute their paid leave. We can also require employees to satisfy any procedural requirements of the paid leave policy. So what we need to do, if we want employees to substitute paid leave, then for the period of time that the leave is covered by Wisconsin and federal, then we can't require it. But as soon as they've exhausted their Wisconsin FMLA, then at that time you can go ahead and require them to substitute their paid leave. So for a serious health condition, for the first 2 weeks of leave, employees can choose to substitute paid leave, but we can't require them. Once the first 2 weeks are up and we have 10 weeks remaining, then we can require the employee to use their accrued paid leave during that time. I'm not going to touch on this too long, but just wanted to note, under Wisconsin law, there are circumstances in which, yes, you as an employer can require employees to prepay insurance premiums. Under federal law, you can't require prepayment. And so practically speaking, one, it's pretty burdensome for employers to go through all the hurdles to require prepayment. And then two, knowing that you can't require prepayment under federal law, you'd only be able to do that for exclusively Wisconsin leave. So employers really don't do this. If you're interested in doing it, I would talk to your attorney about making sure it's being set up correctly. With reinstatement, the rules are pretty similar between Wisconsin and federal law. Employers have to reinstate employees to the same or an equivalent position. Note, however, that an employee doesn't have a greater right to reinstatement or to other benefits than if they had been continuously employed during their FMLA leave period. So what that means is if they're on leave and you're going through Nancy, do you know how to take that off? Thanks. So if you're going through a restructuring while they're on FMLA leave, and regardless of whether they would have been employed working during that time period or not, you would have eliminated the position. FMLA doesn't mean you can no longer take that action. if you were going to and want to eliminate the position for reasons unrelated to FMLA, you can go ahead and do that. Federal law, however, provides an exception to reinstatement for key employees. A key employee is defined as a salaried FMLA-eligible employee who's among the highest paid 10% of all employees who are working for the employer within 75 miles of the employee's work site, and I'll repeat that. It's a salaried FMLA-eligible employee who's among the highest paid 10% of the employees who work for the employer within 75 miles of the employee's work site. If reinstating a key employee would cause substantial and grievous economic injury to the employer, then reinstatement may not be required. It's difficult for employers to satisfy this, and so if you think that you have a circumstance in which you have a key employee and you don't think reinstatement is going to work, again, work with your attorney on that. Wisconsin doesn't have this exception, and so if the leave is covered by Wisconsin law, you must reinstate. It's only once the leave is covered just by federal that you could potentially take advantage of this exception. Okay. A few thoughts on your FMLA policies and forms in light of the information we just went over. One, make sure your handbook has an FMLA policy. This is required. The handbook has to contain all the provisions of the DOL's FMLA poster. This poster includes statements that advise employees how they can sue their employer. And so I see employers who include most of the statements, but not all of them. That's not good enough. You have to include all the statements in your policy. You can attach this policy as an appendix to your handbook instead of incorporating it into your FMLA policy. My only concern with doing that is if you later have an employee who's printing the handbook and doesn't realize they need to attach that appendix, then you wouldn't be in compliance. And so it's the safer approach may be to just incorporate the terms into your policy, but know that you do have the option of attaching it. Make sure that your policy addresses Wisconsin FMLA. As you've seen this morning, there's ways in which the two laws are very different. If you are only talking about federal FMLA, that's a problem, and your policy should be revised to reference Wisconsin FMLA and also make sure that it covers the ways in which they're different. If you want a copy of that DOL poster I referenced, feel free to leave your business card with Nancy, and we'll make sure that you get a copy of that poster. The other recommendation that I have, and I mentioned earlier, is to revise the designation notice that you're using to make sure that it specifically references Wisconsin FMLA, so you can designate whether the leave is counting as federal, state, or both. On your notice of eligibility form, which is another form available from the Department of Labor, and as well as in your designation notice, there's questions that relate to substitution of paid leave. This too should be revised because of the different rules under Wisconsin, where I would say under Wisconsin law, you have the ability to elect to substitute your accrued paid leave. You know, do you want to do so, and if so, how much? And then if you're going to require it under federal law, then you would include a separate question that says, you know, if your leave is only covered by federal law, then the employer will require it, and here's how much we're going to be substituting. But they need to be addressed separately, and again, the Department of Labor's forms don't do that. I'm going to go through a few examples here that illustrate the principles we've discussed this morning. The first, we have Susie Smith, who just informed her manager that she's pregnant. She goes to HR with a list of questions. Her first question is, how will my prenatal appointments be treated? Does anyone have a response? Yes?
I would absolutely
would inform the FMLA certification form, and then the correct. She should know that it would be considered, time off for a serious health condition, and that there would be 2 weeks available under Wisconsin and 12 weeks under federal. Her next question is, what happens if I develop complications? So here, response would be similar. Any complications would be treated as a serious health condition and would be counted against her FMLA entitlement. So she also asks, how much can I take after I deliver? And will it be paid? Any thoughts? So we'd be looking here at a minimum of 6 weeks that she'd get under Wisconsin, because even if she used time before for prenatal, that would be considered, time for her serious health condition. And so she'd, again, at a minimum get 6 weeks of Wisconsin, and then she'd get whatever the balance is of her available federal FMLA leave. As I mentioned earlier, if her pregnancy or maternity leave should extend into 2 calendar years, and you're using a calendar leave year system, then she could receive more than 12 weeks because she'd be getting 12 weeks per calendar year. With respect to her question, will it be paid? I'd advise her that she has the right to substitute paid leave under Wisconsin FMLA, and then inform her of what your policy is for substitution under federal FMLA. I'd also encourage you to see if there's other benefits she might qualify for, perhaps under a short-term disability plan. She asks whether she can work part-time or on a reduced schedule following the birth. So here, under Wisconsin FMLA leave, yes, she can. But once she's exhausted those 6 weeks of Wisconsin FMLA leave, then she can work part-time only if, as an employer, we allow her to. Her next question is, when does the period for leave in connection with this birth expire? So under federal law, it would expire at the end of the 12-month period following the birth. And under Wisconsin, it would expire when the 6 weeks are exhausted. That, practically speaking, that generally happens before the period of leave would expire under federal law, since Wisconsin FMLA must begin within 16 weeks of the child's birth. So she discloses that the father of the baby is her boyfriend, and he also works for the company. Does he have any rights? He has rights to care for the child, to bond with the child, but he doesn't have any rights to care for the girlfriend unless she might satisfy Wisconsin's definition of a domestic partner, because girlfriends and boyfriends aren't covered. I included this example because it's a common question I get from employers. We have an employee in the accounts receivable department who's on leave to care for her newborn child. While she's gone, the company discovers that she's failed to deposit hundreds of checks totaling over $350,000 over the past year. The employee recently informed the company, though, that she might need more time off because her newborn was diagnosed with a life-threatening condition. What do you do? Ann?
I would get in touch with this employee and let them know that this is now a caretaking issue, and advise the employee that certification forms are needed. In my line of work, the service is failing to deposit that money. We keep our FMLA and I want to say disciplinary type things separately. So you have to report that to somebody else, and
Great. The point that I make here too is, even though she's on FMLA and is saying, wow, I'm having more issues, I might need more time off, if you as a company don't tolerate that type of performance issue, then you can act immediately and terminate her. You don't need to wait for her to return in order to do that. But I'd make sure before doing that that that's consistent with your policy and your past practice. The other thing that you would need to be aware of is, yes, she could still claim that perhaps the decision was motivated by FMLA. We would defend the claim and say, no, it had nothing to do with FMLA. It had to do with these performance issues that we discovered. The other potential concern that I would have is perhaps she would claim that you discriminated against her under the ADA because she's associated with someone with a disability. Just things to consider. Okay. In our next example, we have an employee who's requested FMLA leave because she has migraines. She might need to come in late or leave early when she's experiencing symptoms. This is going to pose a significant hardship on the company. Although she's paid $12 an hour, she's highly valued. She's the only employee who can operate the press machine. Without her on the assembly line, all production will cease. What do you do? So can we ask her to take a different position, or can we require her to take a different position and train someone else to operate that machine? We can't. And the reason is because her leave's unforeseeable. Federal law doesn't allow it, and Wisconsin wouldn't either. We could ask her, but if she refused to consent, we'd really be stuck with this situation. Hardship is not a defense under FMLA. Under federal law, she wouldn't qualify as a key employee that perhaps we could refuse to reinstate because she's paid hourly. And key employees have to be paid on a salaried basis. Now, once her state and federal FMLA have been exhausted, then we'd be looking at our obligations under the ADA. And we'd say, if she needs more time off or if she needs to continue to come and go as she pleases, is that a reasonable accommodation under the ADA? I think there's an argument that that's not a reasonable accommodation, but something we'd want to analyze at that time. Okay. All right, our last example. From March to May, we have a male employee who's used 12 weeks of FMLA leave to care for his wife, who was on bed rest during her pregnancy due to complications. After his child is born, he announces that he intends to take time off to care for his baby, who does not have any health issues. The company has been eagerly awaiting his return, and his supervisor expresses to HR that his absence will result in the department not meeting its sales goals. What do you do? So we'd want to look to see what's the current leave year. Has he exhausted all his federal FMLA leave for the year? Even if he's exhausted all his federal FMLA leave, he's still entitled to 6 weeks under Wisconsin FMLA. So the employee returns to work after the 6 weeks of leave to care for his child. He then announces that he needs 8 weeks off because he was diagnosed with cancer and he's going to need treatments. What do you do? So here, oh, yes, Ann.
I would notify the employee and inform him that his schedule's been exhausted, that he would have 2 weeks under the state, so we would have that with him.
Correct. So we would confirm that he's exhausted all his federal FMLA, again, depending on the leave year, and then he would be entitled to 2 weeks off under Wisconsin FMLA. But what we need to do, he still has an additional request for 6 weeks due to his cancer. So instead of just refusing the leave or possibly terminating him, we'd be looking at the ADA and say, is granting 6 more weeks of leave a reasonable accommodation under the ADA? Cancer almost always is a disability. Here, it may be that an additional 6 weeks of leave is a reasonable accommodation. So those are the examples that I have. If you have questions, I'm happy to take them. I understand there's some questions from those who are participating on the web. Before I take the questions, I wanted to let you know, too, that the Department of Workforce Development provided a chart that outlines these differences, not in the detail that we've discussed today, but if you'd like a copy of that chart, also feel free to leave Nancy with your business card and we can get that to you. All right, so one of the questions that we have, it says, our policy states that employees are not eligible for attendance bonuses if they are absent on FMLA leave. Is that permissible? This is also a common question that I get from employers. What you need to do is you need to look at how other absences are treated. So if the FMLA leave is unpaid and you say, in your attendance policy that unpaid absences will disqualify you, then you could disqualify the individual because you're treating them the same as your non-FMLA absences. Now, if the employee is substituting paid time off while on FMLA, such as vacation, and your attendance bonus policy says PTO will not be counted against you for purposes of determining the attendance bonus, then you couldn't hold those FMLA absences against the employee when determining whether they're eligible for the attendance bonus, because you'd want to treat their paid FMLA leave the same as you treat other paid absences. Does that make sense? Okay. Another question I got is, can I change the leave year that we're using? Yes, you can. You have to give employees 60 days notice prior to doing that. You also have to make sure that the employees receive the full benefit of 12 weeks of leave. Even with the change, you wouldn't want them to, if you're changing it such that under the new leave they'd only have 2 weeks available, but if you continue under the calendar, they'd have 10 more weeks available. You'd want to make sure that they're not harmed by your change during that transition. All right, another question. We require employees to specifically request FMLA leave. An employee is claiming we should have known that his absences were due to migraine, that his absences due to migraines qualified for FMLA, and we shouldn't be disciplining him for those absences. What should we do? Great question. So an employee doesn't have to specifically say FMLA when they're requesting time off. You should train your supervisors on how to field calls regarding sickness, illness, injury, so that if they're calling about a condition that could qualify as a serious health condition, that they're getting HR involved. If they call their supervisor and said, I'm going to be gone today because of migraines, that should be a trigger to the supervisor to let HR know, so that HR could then provide the employee with the certification form, so we're not getting to a point where the employee is about to be disciplined for absences that really should have been treated as FMLA. Okay. Another question, can FMLA and Wisconsin FMLA be tracked concurrently? Yes, and so if the leave qualifies under both, then you would want to count it against their entitlement to both. Any questions, other questions on that? Does that make sense? Okay. Okay. A question is, if a woman is pregnant and goes on bed rest that requires FMLA leave, is that a separate health condition than when the child is actually born? Should they be entitled to 2 separate FMLA allotments? So under federal law, assuming that we're just concerned about 1 leave year, it'd be a total of 12 weeks that this employee would get for the bed rest and then following the birth of the child. So all of that time off, maximum of 12 weeks. Wisconsin's different in saying that the bed rest would be treated as a serious health condition, so it would count against her 2 weeks of Wisconsin leave for a serious health condition. Once the child's born, the employee would be eligible for 6 weeks of Wisconsin FMLA to care for her child. So example where this comes up is if the employee was on bed rest for, let's say, 12 weeks before the child was born. Some employers are inclined to say, well, you've used all your FMLA leave, you have no more left following the birth of your child. That's not right. If they've used the 12 weeks because the woman was on bed rest prior to the birth of the child, then once the child's born, that employee would still have 6 weeks of leave available under Wisconsin FMLA. Okay, a question. What if you give them federal leave early when they aren't entitled to it? Can they still get it later when they reach their federal hours? What I would do here is if you want to give them the time off, even though they're not entitled to it, call it something else. If you have a policy that's non-FMLA medical leave or personal leave, the problem with calling it FMLA leave is then the employee gets all the protections and rights, and you're also having to ensure compliance with reinstatement. And so I'm not opposed to employers being generous and giving employees the time off, even if they don't qualify for it under federal or state family and medical leave, but just call it something else. But as to this particular question, if you've already done that, once they reach their federal hours, then they should get the full 12 weeks at that time, because technically that prior leave shouldn't have been counted against their federal hours. If an employee is calling in sick for a condition related to pregnancy but is not requesting FMLA leave, can an employer send them a notice of eligibility and or require them to use FMLA leave? This is another great question. I've dealt with many employers who have employees that don't want to use FMLA leave. They just want to use their PTO days. That's a problem. If the condition qualifies for FMLA leave, we need to be counting it against their FMLA as a best practice. And the reason being, if we have an employee who, let's say, uses 4 weeks of PTO, they don't want to use FMLA, and we let them do that. And then a month later they say, oh, you know, my mom got really sick, I need 12 weeks off. Well, then they really have gotten 16 weeks of leave off, whereas if we had counted the initial 4 weeks of leave, they'd be limited to that 8 weeks of leave under federal law. And so I discourage employers from permitting employees to elect not to use FMLA. If it qualifies for FMLA, send them the notice, send them the paperwork. If an employee refuses to submit it, I'd maybe reach out to an attorney, because it may be that we can still designate it despite their lack of cooperation. It would depend a bit on the facts. Okay, we've got 1 minute left, so I'll see if I can find a short question here. One question, which is an easy one, will a recording of this webinar be available? Yes, it will be. And let's see. A question about migraines. An employee is a CNA. She calls in a few hours before starting her shift and informs the employer she can't come in due to a migraine. Do we require a statement from the doctor? What do we do? If this is the first time that it's happened, then I would give her the FMLA paperwork. But otherwise, assuming that she has a certification on file and that her absences related to the migraine are consistent with the information in the certification, It would be unlawful interference to require her to bring a statement each time that she has an absence due to FMLA. We are at the end of the seminar. For the people who are here attending, I'll stay after to take any questions that you may have because I realize I took the questions from the webinar first. Thank you all for attending. I appreciate it. Have a great day.